Good evening and welcome. It is just about 11 o'clock. I'm Teddy, and it is Analyze This Mess. The court recommends default judgment, Evans versus Robertson. So just give me one more second setup. Let me know that the sound is good before I pull anything back. And shout out to the mob, all my other bears. I call the Grizzlies and the Honey Bears. Please hit the like on your way in. Please be respectful as you come into the chat. And if you are making comments, that's just a reminder. I would appreciate it. If you'd like to subscribe to this channel, go right ahead and do so. But we appreciate participation, up or down. That's what we like. All right, so the sound is good. All right, so let me just make sure I have the background that I want. I'll just start off with this one, the one that's up. Let's pull this back. That's the background. And let me just put the thumbnail up. And we'll start from there. All right. All right, so my mic is open, and I've already told you tonight is D for default judgment. Court recommends default judgment. So, good evening, everybody. And again, welcome to Analyze This Mess. Tonight, I want to do something maybe just a little bit different, but I want to go somewhere with this, all right? So please listen carefully. And I'd like to just start off. You know what? Let me just change this for a second. Let's just go here so that I don't have any distraction with that banner. I want to start with recognizing God. Ephesians 6:10 through 18. Because today I receive two significant developments in my federal case. And yes, I'm excited, but it's tempered. All right. But before I talk about a recommendation for default judgment, before I begin talking about discovery or talking about subpoenas, and before I talk about what happens next, I want to remember how we're supposed to stand. Ephesians chapter 6 tells us to put on the whole armor of God. And there is one part in this passage that I especially want us to remember tonight. For we wrestle not against flesh and blood. That's important because this isn't supposed to be about hatred. It isn't supposed to be about vengeance. And it isn't supposed to be about destroying another human being. It's about standing in truth, standing in righteousness, standing with faith, and standing in peace, and carrying the sword of the Spirit, which is the Word of God. There have been times during this journey when I wanted things to happen faster. There have been disappointments. There have been setbacks. There have been moments when the answer was no. There have been moments when the answer was wait. But Ephesians doesn't say, having done everything, panic. It doesn't say, having done everything, retaliate. It says, having done all, stand. And that's what I want to talk about tonight, because today I was still standing. All right, so we're going to get right into this, and let's see if I can pull up. I know you were waiting for that clock. Well, that clock has something to do with this too. But we will get to all of that. Oh, let's see here. Tonight, we have something to analyze. Actually, we have two things. Two docket entries. ECF number 175 and ECF 176, both entered today. And before we get into either one, I want to make something else very clear, because words matter, particularly when we're talking about federal court. Listen carefully, please. The court has not entered final default judgment. I need to say that again. The court has not entered final default judgment. And let me just make sure that I have. Let's just go here for now. All right. The court in ECF 175 is a report and recommendation, and that's why I put the court has recommended default judgment. That was the magistrate judge is recommending default judgment. There is still a process that follows a report and recommendation. So if you leave here tonight saying Teddy got a default judgment today, that is not what I told you. What I told you is the court has recommended default judgment, and tonight we're going to read it because around here we're not going to depend upon somebody's interpretation of what the court supposedly said. We've got the document, so we're going to analyze it, or at least because its time is late, I'll read through it. For those of you who haven't followed every twist and turn of this litigation, let me give you enough background to understand why today's recommendation matters. Now I want to see if I can take down my clock and put up. Just hang on for one quick second. See if I can switch this out. Take that down. Hang on just 1 second. And thank you for being patient. Hang on. Change this. All right. For some reason, okay, let's remove this. All right. But for those of you who have followed every twist and every turn of this litigation, I appreciate your support. Federal litigation is procedural. There are rules, there are deadlines, there are orders, there are obligations placed upon plaintiffs, and there are obligations placed upon defendants. And when a court enters an order, the parties don't get to decide whether the order is convenient. You comply with it, or eventually the court has to decide what to do about the failure to comply. And that brings us to ECF 175. Today, the magistrate judge issued a report and recommendation addressing what has happened in this litigation, and the recommendation, default judgment. Now, I'm going to stop talking for a moment because I want you to hear what the court actually wrote. So I'm going to put it up on the screen. ECF 175. And we are going to do this. I think you can see it. maybe this is a little better. All right, so this is ECF 175, filed today on the 6th of August in the United States District Court, Eastern District of Michigan, Southern Division. Sabrina Evans, plaintiff versus Daniel Robertson et al., defendants in the case 24-CV 13435. Honorable Judith E. Levy, Magistrate Judge Elizabeth A. Stafford. Report and recommendation to enter a default judgment against defendant. 1. Introduction. Plaintiff Sabrina Evans, proceeding pro se, sues defendant Daniel Robertson, 1. and Jane Does 1 through 10 for copyright infringement, defamation, fraud, and harassment. ECF number 1. The Honorable Judith E. Levy referred the case to the undersigned for all pretrial matters under 28 U.S.C. 636b1, ECF number 7. Subscript. Robertson made a special appearance as Jane Doe, stating that Daniel Robertson is an online alias and not her legal name. ECF number 28, page ID 183. For the sake of clarity, the court will nevertheless refer to this individual as Robertson. Evans moved for an order requiring Robertson to show cause why she should not be held in contempt and sanctioned for disobeying 2 of Judge Levy's orders to disclose her identity. ECF number 118, ECF number 124. And let me just make sure the comments are on the screen. That way I can see them. The court granted the motion, and Robertson was ordered to show cause why she should not be sanctioned. ECF number 144. Robertson responded that the court should defer enforcement of Judge Levy's orders until it resolves the viability of Evans' claims. ECF number 150. The orderly and expeditious administration of justice by the courts requires that an order issued by a court with jurisdiction over the subject matter and person must be obeyed by the parties until it is reversed by orderly and proper proceedings. Manis versus Myers, 419 U.S. 449, 459, 1975, cleaned up. Because of this bedrock principle, Robertson should be sanctioned with a default judgment for her violations of Judge Levy's orders. Background. 2. Evans, a Michigan resident, alleges that Robertson engaged in a pervasive campaign of harassment and cyberbullying on her social media platforms and websites from 2022 to 2024. Superscript 2, ECF number 1, page ID 7 through 9. Footnote 2, Robertson's alleged social media usernames include Danny Montana, Danny Robertson, Truth Teller Danny, Lori Davis, Unhinged with Bundy. And let's just continue to, I think that finishes up 2. No. Woo Child the Ghetto, Danny Monroe, Public Awareness to Medical Malpractice and for the Basics, ECF number 1, page ID 46914. Her websites include messydanny.com and ican't.com. Page ID 8. Evans contends that Robertson changed at least one of these usernames and removed content after this action was filed. ECF number 64, page ID 604. Let me go back to page 2. Robertson allegedly posted YouTube videos calling Robertson Teddy Bundy and falsely accusing her of stalking and other crimes. Page ID 8, 15, 45 through 47, 75, ECF number 67, page ID 654. Evans also alleges that Robertson published deep fake pornography using Evans' likeness. Page ID 9, 42, 50. In a YouTube video, Robertson allegedly discussed Evans' divorce and published documents from those proceedings and encouraged her followers to likewise post content harassing Evans. Page ID 12, 74 through 75, ECF number 67, page ID 667. Posing as Evans' family member, Robertson allegedly made several fraudulent calls to local police to report concerns about Evans' mental health and animal cruelty. ECF number 1, page ID 10. Officers then performed wellness checks on Evans and recorded her on body cam. Page ID 1052. Evans claims that Robertson obtained the body cam footage through a Freedom of Information Act request and published content from the footage to YouTube and her websites. Page ID 1054, ECF number 65, page ID 606, ECF number 67, page ID 658. Evans next alleges that Robertson conspired with an unnamed petitioner to obtain a personal protective order, PPO, against Evans, posted about a hearing on the PPO, and published the PPO on her website. ECF number 1, page ID 15, 38 through 41, ECF number 66, page ID 644. Let me just check the chat or with my moderator. Can you see the writing okay? I'm going to continue. Let me just look to you. And thank you. All comments and opinions in the chat are allegedly and their own. In social media postings, Robertson allegedly accused Evans, a physician assistant, of being found guilty of medical malpractice. ECF number 1, page ID 8 through 949. Evans claims that Robertson later reported her for professional misconduct to Michigan's Department of Licensing and Regulatory Affairs, LARA. Page ID 9 through 11. See also ECF number 66, page ID 633, 639. One of the complaints was allegedly made by the PPO petitioner in coordination with Robertson, as Robertson posted about the complaint and published a letter from Lara on YouTube and her website. ECF number 1, page ID 1158 through 61, ECF number 66, page ID 637, 640. Let's take this comment down. Robertson also urged her social media followers to file anonymous complaints against Evans and provided links to the required forms on the LARA website. ECF number 1, page ID 9 through 10, 49, 51, 55 through 56. One alleged post states, Michigan complaint form. You can file anon. There's an option to report possible drug abuse. Let me reread that. There's an option to report possible drug substance abuse, such as her alleged but apparent alcohol consumption, and a box to fill in complaints such as mental illness, etc. Link to LARA website. Here's the information needed to complete the complaint. 2 more links. ID, page ID 51, ECF number 68, page ID 670. And Evans claims that Robertson created a change.org petition accusing Evans of unethical behavior and seeking to damage her professional reputation. ECF number 1, page ID 15, ECF number 67, page ID 647. One post promoting the petition states, Hey everyone, as stated, I was going to create a PSA petition for Michigan patients and people worldwide to be aware of unethical physician assistants who cyberbully, dox, and harass innocent people. Evans, PA, is currently under investigation with the medical board. Other officials and agencies are also being made aware of her unethical behavior. Sign the petition here. Link to change.org website. ECF number 1, page ID 48. The unethical behavior Robertson alleged in the petition, including stalking, doxing, there's a superscript 3, and cyberbullying. ECF number 68, page ID 674. LARA informed Evans that no violations could be substantiated and closed the matters. ECF number 1, page ID 10 through 11, 57, ECF number 66, page ID 636. Let me read the footnote here. 3. Doxing is the practice of publicly disclosing a person's identifying information, such as their home address or their social media username, in hopes that others will likewise harass the outed person, which is plastering their Facebook wall with hateful comments. That's in the citation Van Huvue or Van Lu versus Got News LLC 365 F Sup 3D 850 852 860 Eastern District, Michigan 2019. Let me continue. I'm just looking at the time and trying to cover this. Evans has her own YouTube channels. Unwind with Teddy and Run Tell That Too. ECF number 1, page ID 12. Robertson allegedly impersonated others to file hundreds of false copyright and privacy complaints with YouTube, claiming ownership of Evans' content. page ID 12, 14, 62 through 68. YouTube terminated Evans' accounts, but later reinstated some videos after finding the claims invalid. page ID 12, 14. Robertson also allegedly filed multiple copyright infringement claims against Evans with the Copyright Claims Board, page ID 12, 14, 69 through 70. 3 of Evans' claims survived Robertson's motion to dismiss. 1. Copyright infringement stemming from the use of Evans' likeness. 2. Defamation stemming from Robertson's alleged post about Evans' professional misconduct, false reports to police, and posts including body cam footage, and 3. Cyberbullying and harassment stemming from Robertson's post about Evans' divorce. ECF number 75, page ID 825, ECF number 112. In September 2025, the court considered several motions involving Robertson's positions that she should be allowed to proceed anonymously and that the action should be dismissed because Evans failed to serve her properly or use her legal name. ECF number 74, page ID 774 through 778, 780 through 781. ECF number 75, page ID 813 through 823. Finding that Robertson may not use her anonymity simultaneously as a shield to protect her privacy and as a sword to undermine the litigation. The court ordered alternate service on Robertson's email address and that Robertson disclose her legal name and postal address. ECF number 74, page ID 778, 781. Robertson objected to the order, and Judge Levy stayed the requirement that she disclose her identity pending resolution of those objections. ECF number 82, ECF number 95. Judge Levy then overruled Robertson's objections and ordered her to disclose her legal name and postal address by December 15, 2025. ECF number 118, page ID 2384 through 2393. Robertson did not comply and instead moved for reconsideration on December 18, 2025. ECF number 121. Judge Levy struck Robertson's motion for reconsideration because it contained a fictitious citation and ordered Robertson to disclose her legal name and postal address by January 5th, 2026. ECF number 124, page ID 2636. Again, Robertson did not comply. Section 3, analysis. A. It is settled law that federal courts have the inherent authority to punish those who violate court orders. Martinez versus Blue Star Farms Incorporated, 325 FRD 212 224 WD Mish 2018 or 2018. Citing International Union United Mine Workers of America versus Bagwell 512 US 821 831 1994. The court's inherent powers include the powers to impose silence, respect, and decorum in their presence, and submission to their lawful mandates. And as a corollary to this proposition, to preserve themselves and their officers from the approach and insult of pollution. By the way, this is my first time reading this court order in its fullness. Whiting versus City of Athens, 170 F 4th 455 462. Sixth Circuit 2026 cleaned up. Thus, when a party refuses to submit to a lawsuit mandate set forth in an order, a court may use its inherent power to impose punishment. Chambers versus NASCO Incorporated, 501 U.S. 3244 1991. Sanctions permitted under the court's inherent authority include contempt citations, fines, awards of attorneys' fees, and such other orders and sanctions as courts find necessary, including even dismissals and default judgments. Dell Incorporated versus Abacon Computer Services Inc., numbers 06-11224 or 11,224, 2007, Westlaw 2021-1842 at 5 ED Mish, July 12, 2007, quoting Shepard versus American Broadcasts Inc., 62 F3D 1469, 1472, DC Circuit 1995. See also Ing Re Sunshine Junior Stores Incorporated. That's in Ray. 456 F.3D 1291, 1304 through 06, 11th Circuit 2006, affirming entry of default judgment under the court's inherent. Because violated court's orders. Thomas Head Grissing Employees Trust versus Buster, 95 F3D 1449, 1457 through 59, 9th Circuit 1996, affirming default judgment under inherent authority when defendants violated terms of preliminary injunction and other orders. Default judgment is warranted when no alternate sanction would protect the integrity of the judicial process. Bradley J. Delph, Revocable TR versus MSJMR 2008, Irrevocable TR 600 565, F Appendix 514, 524, Sixth Circuit, 2016. The court has a duty to uphold the integrity and sanctity of the court's orders. I don't usually read this fast nor speak this fast, but I'm trying to get through this. So my apologies if I stumble over word or mispronounce something. United States versus Hall, 153F, Supplement 661, 664, WD, Kentucky, 1957. Although entry of default judgment is a drastic measure, the district court does not abuse its discretion in entering a default judgment to punish a party for egregious conduct and to deter other litigants who might be tempted to make a mockery of the judicial proceedings. Grange Mutual Cass Company versus Mac, 270F Appendix 372, 378, Sixth Circuit, 2008. 4 factors guide whether a default judgment is proper. 1. Whether the conduct at issue was the result of willfulness, bad faith, or fault. 2. Whether the adversary was prejudiced by the disobedient party's conduct. 3. Whether the disobedient party was warned that failure to cooperate could lead to default judgment. And 4. Whether less drastic sanctions were imposed or considered before entry of default judgment. And superscript 4, subscript, here it is. These factors apply whether proceeding under Federal Rules of Civil Procedure 16F 3741B or the court's inherent authority. Coleman versus KCI USA Inc. versus Healthcare Essentials Inc. 801 F Appendix 928, 934, Sixth Circuit, 2020. Although no one factor is dispositive, bad faith is the preeminent consideration. Pharmacy Records versus Nasser, 379 F Appendix 522, 524, Sixth Circuit, 2010. Applying these factors, default judgment is proper here. 1. For the first factor to qualify as bad faith, willfulness, or fault, a party's conduct must display either an intent to thwart judicial proceedings or a reckless disregard for the effect of her conduct on those proceedings. Malba versus Detroit BD or Board of Education, 261 F3D 586, 591, Sixth Circuit, 2001, cleaned up. There must be a clear record of delay or contumacious conduct, that is, perverse in resisting authority and stubbornly disobedient. Carpenter versus City of Flint, 723, F3D 700, 704 through 5, 6th Circuit, 213 cleaned up. Robertson has stubbornly disobeyed Judge Levy's orders for her to disclose her identity. And a court order must be obeyed by the parties until it is reversed by orderly and proper proceedings. United States versus Hendrickson, 822, F3D 812, 818, 6th Circuit, 2016, quoting United Mine Workers 330 U.S. at 293. Let's read that. Footnote. American Red Cross 23 F3D 1091, 1094, number 1, 6th Circuit, 1994. Hardy versus Whitaker, 351 FRD 84, 100, number 10, Eastern District, Michigan, 2026. Even if an order is erroneous, the remedy is to appeal unless enforcement of the order is stayed. Manus 419 U.S. at 458. Judge Levy twice ordered Robertson to disclose her identity, and Robertson defied both orders. ECF number 118, ECF number 124. Litigants like Robertson, who make private determinations of the law and refuse to obey an order, generally risk criminal contempt, even if the order is ultimately ruled incorrect. Manus 419, U.S. at 458. True, a party may try to avoid finding of contempt. Reread. True, a party may try to avoid a finding of contempt when complying with an invalid order would necessarily result in an irrevocable and permanent surrender of a constitutional right. Kleiner versus First National Bank of Atlanta, 751 F2D 1193, 1208, 11th Circuit, 1985, cleaned up. This exception has been applied when a witness refuses to testify about information implicating the Fifth Amendment privilege against self-incrimination. Manus 419, U.S. at 460 through 61. Legal experts have advocated for the exception to apply when a litigant violates ex parte injunctions restraining First Amendment speech rights. But thus far, the exception has not extended beyond the limited confines of self-incrimination. In re Establishment Inspection of Hearn Iron Works Incorporated, 881 F2D 722, 728, 9th Circuit, 1989. See also Kleiner, 751, F2D at 1208. The Supreme Court emphatically rejected the suggestion that an individual may disregard a court order simply because it interfered with his exercise of First Amendment rights. Cleaned up. United States versus Donziger, number 19, CR 561, 2001, Westlaw 314, 1893. At 60, number 573, Southern District, New York, July 26, 2021. Other courts have expressly declined to extend Manus beyond its facts. To justify her continued defiance, Robertson repeats her arguments from her October 2025 motion to dismiss that the orders to disclose her identity violate the First Amendment protection against unmasking anonymous online critics. ECF number 150, page ID 3393, 3398. ECF number 77, page ID 994, citing In re Anonymous Online Speakers 661 F3D 1168, 1173 through 76, 9th Circuit 2011. Robertson is correct that an author's decision to remain anonymous is an aspect of the freedom of speech protected by the First Amendment. Signature Management Team, LLC versus Doe, 876 F3D 832 835, 6th Circuit 2017, cleaned up. In litigation involving anonymous internet users, courts have weighed the validity of the claims and the plaintiff's need to uncover the user's identity against the First Amendment's protection of anonymous speech. See e.g. id at 834, Sony Music Entertainment Inc. versus Doe's 1 through 40, 326, F Supplemental 2D, 556, 564 through 65, Southern District, New York, 2004. Hang on. Columbia Insurance Company versus SeizCandy.com. 185 FRD 573, 578 through 79, Indy, California, or I think that's Northern District of California, 1999. But Judge Levy's determination that Robertson must disclose her identity is the law of the case and may not be revisited absent extraordinary circumstances. See Hayden versus Rhode Island 13 F Appendix 301, 302, 6th Circuit 2001. Under the law of the case doctrine, findings made at one point in the litigation become the law of the case for subsequent stages of that same litigation. Let me take just a quick break for a piece of hard candy. It is 6 minutes to midnight. I wanted to try to get through this because the second order is quite important. A prior ruling may only be reconsidered where 1. Substantially different evidence is raised on subsequent trial, where a subsequent contrary view of the law is decided by the controlling authority, or 3, where a decision is clearly erroneous and would work a manifest injustice. United States versus Haynes, 468, F3D, 422, 426, Sixth Circuit, 2006, cleaned up. And also, if you have never listened to me, my speaking voice tone is softer. I don't yell. It strains my voice for me to just, try to articulate and read fast and say this very loudly. All right. That's not how I normally speak. Not for comprehension. Robertson seems to argue that Judge Levy's orders for her to disclose her identity were clearly erroneous and would work a manifest injustice. But her skeletal arguments fall short. See ECF number 153, page ID 3341 through 3443. Anne Robertson waived her First Amendment argument by failing to assert it in any of her previously filed briefs about the anonymity issue. See Evanston Insurance Company versus Cogswell Props LLC numbers 1:09-CV 996. That's case 2010 Westlaw 1169-61694. It actually would just read 1169-1694 at 2. Western District, Michigan, August 12, 2010. Although she made the argument in a motion to dismiss, that motion did not concern the orders to disclose her identity. Neither the court nor Judge Levy was obligated to scour the record on Robertson's behalf to develop her arguments. See Sutherland versus Warren, case number 1800 or 18-CV 13568. 2019 Westlaw 13368706 at 2 ED Mish, December 6, 2019, adopted 2020. Westlaw 13789-265. Eastern District, Michigan, February 10, 2020. Declining to review hundreds of pages of documents that were in the record but were not attached to the relevant motion. As the court has warned the parties, judges are not like pigs, hunting for truffles that might be buried in the record. Nightcap Partners Corp. versus Hinkle AG and Company, KGAA 930 F3D 775, 780, number 1, 6th Circuit, 2019. Robertson made no First Amendment argument in seeking a protective order preventing Evans from obtaining discovery about her identity. ECF number 28. Robertson did refer to the First Amendment when opposing Evans' motion to strike filings Robertson made under her alias, but only in a fake quotation misattributed to Doe versus Porter. 370 F3D 558 560 6th Circuit 2004. ECF number 49, page ID 469. See also ECF number 74, page ID 774. The court had no duty to develop Robertson's First Amendment argument. Issues averted in a perfunctory manner, unaccompanied by some effort at developed argumentation, are deemed waived. It is not sufficient for a party to mention a possible argument in the most skeletal way, leaving the court to put flesh on its bones. McPherson versus Kelsey, 125 F3D 989, 995 through 96, 6th Circuit, 1997, cleaned up. In the same manner, in the same vein, issues not presented to a magistrate judge in the first instance are waived. See Ward versus County of Wayne, number 21, CV 12742, 2024, Westlaw 1174-555 at 8-9 ED Mish, March 19, 2024. Let me get to some conclusion, or at least a portion, so I can get to the other order. Take your time, don't rush. Thank you. Robertson also made no First Amendment argument in her objections to this court's order for her to disclose her identity. ECF number 82. In her only mention of the First Amendment, she claimed that the court erred by declining to review evidence before making a dispositive factual conclusion on the safety risks underlying the First Amendment inquiry. Page ID 1145. But Robertson neither cited authority supporting her First Amendment argument nor elaborated on how the court misapplied that authority. Thus, she again waived her First Amendment argument. McPherson 125 F3D 996. And when a defendant does not raise an argument in his objections to the magistrate's report and recommendations, he has forfeited his right to raise that issue on appeal. Berkshire versus Dahl, 924 F3D 520, 530, or 530, 6th Circuit, 2019, cleaned up. Robertson did raise the First Amendment argument in her motion for reconsideration of Judge Levy's order overruling the objections and directing Robertson to disclose her identity. ECF number 121, page ID 2529 through 2533. But Judge Levy struck that motion because Robertson included a fictitious fictitious citation in support of her First Amendment argument. Despite previous sanctions and many warnings that such citations would not be tolerated. Let me just pause and just make a quick commentary. I mean, this is so quick. There are different people that read, teleprompters. Some of the politicians, some of the greatest leaders of our country, some of the first African American presidents speak deliberately, thoughtfully, carefully, and takes his time. Would he start rushing through something just because he's sitting in front of an audience that wants him to read speedily? I don't think so, but I feel the need to. I digress. Forfeiting her First Amendment argument was a justified consequence of Robertson's reckless litigation practices. I may delete that in my edit or not. In the order to show cause, the court explained that Robertson must follow Judge Levy's orders, even if they are later found erroneous, and that Robertson had waived her First Amendment arguments. ECF number 144. Still, Robertson has continued to stubbornly violate the orders, relying on her private determinations about what the law requires. Her stubborn disobedience amounts to bad faith. Let me pause here at 2. And it's just past midnight. Let's see. There's 5 more pages, but can I just go to ECF 176? Because I'm certain you would want to hear a little bit of that. I will continue sometime tomorrow and continue through this because of the lateness of the hour. So let me just pause for a moment. There is so much more in here. But I don't want to do a disservice to myself and others. And for those who don't have the patience, well, they can go to Pacer and you can read it. And you can read it on your channel. How about that? As a matter of fact, you can read until the sun comes up, until the sun goes down. It's public record. I don't, there's nothing I can do to stop that. So you can continue to read this if you'd like tonight. 2. Let me just read this part and then I'm going to go to, we'll stop at page 16 and carry it to the end of the paragraph. Or should I? Yes, let me just carry it to this part, to the end of the page. In her opinion. 2, addressing the second factor, Evans has been and will continue to be prejudiced by Robertson's obstinate refusal to disclose her identity. Let's see. Did we get that on there? Or I covered it up? Has that been covered up since I had my candy? I don't know. 2. Addressing the second factor. Evans has been and will continue to be prejudiced by Robertson's obstinate refusal to disclose her identity. 3 of Evans' claims survive Robertson's motion to dismiss. 1. Copyright infringement stemming from the use of Evans' likeness. 2. Defamation stemming from Robertson's alleged post about Evans' professional misconduct. False reports to the police and posts including body cam footage. And 3. Cyberbullying and harassment stemming from Robertson's post about Evans' divorce. ECF number 75, page ID 825, ECF number 12. As courts have found, the identity of an anonymous online content creator is critical to the success of the plaintiff's defamation claim. We're going to leave it there for this section, and I'm going to go and give you what's in ECF 176 highlights, and then we're going to close this out after I read some comments. We may run to 12:30 or a little past that, but I want to allow for that. All right, so let's put up a cover. And let me ask my moderators, how you doing out there? You can email me at unwinewithteddy@gmail.com. Let's take a look. Just looking. Now I need to go to All right, let's go to ECF 176. It's 6 pages. I think I can get through all of it. Let's take this back. I appreciate those of you who have joined me tonight. Please hit the like on your way out. Thank you. Or now. I would appreciate that. Plaintiff Evans versus Robertson. Same case, 24-CV 13435. Honorable Judith E. Levy and Magistrate Judge Elizabeth A. Stafford. The order denying motion for leave to file proposed amended complaint, granting motion for leave to file third-party subpoenas, and scheduling period for discovery. ECF numbers 160, 166. A. Plaintiff Sabrina Evans, proceeding pro se, sues defendant Daniel Robertson, 1, and Jane Doe's 1 through 10 for copyright infringement, defamation, fraud, and harassment, ECF number 1. The Honorable Judith E. Levy referred the case to the undersigned for all pretrial matters under 28 U.S.C. Footnote: Robertson made a special appearance as a Jane Doe, stating that Danielle Robertson is an online alias and not her legal name. ECF number 28, page ID 183. For the sake of clarity, the court will nevertheless refer to this individual as Robertson. ECF number 7. Because Robertson violated orders requiring her to disclose her identity, the court has recommended that a default judgment be entered against her, ECF 175. The court now denies Evans' motion for leave to amend her complaint, grants her motion to serve third-party subpoenas, and schedules a period for limited discovery. B. Evans' proposed complaint is improper under Federal Rules of Civil Procedure 8 and 10. Listen carefully as I take all of this in. Rule 8 requires a complaint to contain a short and plain statement of the claim, showing that the pleader is entitled to relief, and requires that each allegation be simple, concise, and direct. Federal Rule of Civil P 8A2D1. The rule ensures that the district court and defendants not have to fish a gold coin from a bucket of mud to identify the allegations really at issue. Kinsu versus Corazon, Inc., 5F 4th, 646, 651, 6th Circuit, 2021, cleaned up. To determine whether a complaint violates Rule 8, the key is whether the complaint is so verbose, confused, and redundant that its true substance, if any, is well distinguished, cleaned up. And Rule 10b requires a party to state its claims or defenses in numbered paragraphs, each limited as far as practicable to a single set of circumstances. Evans' proposed amendment is 235 pages, including multiple exhibits. ECF number 160-1, ECF number 160-2, ECF number 160-3. The proposed complaint itself includes no numbered paragraphs until count 6, which started with paragraph 100, ECF number 160, page ID 3558 through 3602. And the narrative format of Evans' complaint suggests that she misunderstands a complaint's purpose, which is to simply give the defendant fair notice of what the plaintiff's claim is and the grounds upon which it rests. That's Swinskowitz versus Soroma. NA 534, US 506, 512, 2002, cleaned up. True. A plaintiff must plead enough facts to make her claims plausible, but the requirement of Rule 8 that pleadings be short and plain remains. HDC LLC versus City of Ann Arbor, 675, F3D 605, 614, 6th Circuit, 2012. Evans' proposed complaint with its lengthy narrative paragraphs and numerous exhibits, reads more like a Federal Rule of Civil Procedure 56 summary, judgment brief, than a short and plain complaint. See Bell versus City of Cleveland, 548, F Supplemental 2D 444, 448 through 49. North District of Ohio, 2008, rejecting defendant's argument that the plaintiff needed to show a genuine issue of fact at the complaint stage and noting that the defendant sought to impose a summary judgment standard, Rule 56, onto the initial pleadings of the case. The court also finds that Evans' goals for amending her complaint will be moot if Judge Levy adopts the report and recommendation R&R to enter a default judgment against Robertson. We'll get into what that means. ECF number 175. With the default judgment, Evans will have a chance to show her entitlement to damages and injunctive relief based on the claims that survive Robertson's motion to dismiss AR1. Copyright infringement stemming from the use of Evans' likeness. 2. Defamation stemming from Robertson's alleged posts about Evans' professional misconduct, false reports to police, and posts including body cam footage. And 3. Cyberbullying and harassment stemming from Robertson's posts about Evans' divorce. At page ID 3946, Evans will not be entitled to more damages if she adds a conspiracy claim. See Takmiko versus Metro Health Systems 488, F Supplemental 3D 571, 577, North District of Ohio, 2020. A party is not entitled to recover twice for the same loss, even if the party would otherwise be able to recover for that loss under separate theories of liability. And Evans' existing claims would allow an injunction that prohibits Robertson from misusing her likeness and engaging in online harassment. For these reasons, the court denies Evans' motion for leave to amend her complaint, ECF number 160. If Judge Levy rejects the R&R, Evans may move for leave to file an amended complaint that complies with Rules 8 and 9. So procedurally, should that occur, then I can come back. This is what she is saying. And amend, move for leave to file an amended complaint that complies. That's said loud and clearly, I understand. Evans, thank you. Evans also moves for leave to serve, this is under C. Evans also moves for leave to serve third-party subpoenas to identify Robertson's identity. ECF number 166. The court grants that motion. The court will permit the parties to engage in discovery limited to 1. Evans serving third-party subpoenas and using any other means permitted under the discovery rules to identify Robertson's identity. And 2, allowing Robertson to conduct discovery related to Evans' requested relief. This period for limited discovery will close on November 13, 2026. It is so ordered, dated today, August 6, Elizabeth A. Stafford, United States Magistrate Judge. It is just about 12:24. I'm going to stop here with reading. I will come back. We will go over more of this in a deeper dive analysis. What these things mean, because I want you to hear what the court actually wrote. Now, let me just throw this up here for a minute. I didn't rush it, but I did in reading it. Okay. I stopped some, I pause. But I'll say this. There it is. Not my words. Not somebody on a panel. Not a community post. Not a rumor. Not somebody's interpretation of the docket. That's the report and recommendation. And also ECF 176 or 176 and 175, which I will finish tomorrow. So some of you may be wondering, what is a report and recommendation? The magistrate judge has made a recommendation to the district judge. That recommendation does not automatically become the final judgment simply because it was issued today. I want to make that clear again. There is a procedural process that follows, and that is precisely why throughout tonight's discussion, you heard me use one particular word, also on my thumbnail, recommended, bolded, not entered, not finalized, recommended. That's not me minimizing what happened. That's me accurately describing what happened. And frankly, the recommendation is significant enough that it doesn't need embellishment. How did we get here? This case had a long procedural history. And those of you who have been following Analyze This Mess already know that. There have been questions involving service, jurisdiction, identity, discovery, motions, responses, objections, court orders, and deadlines. And through all of it, the case has continued moving forward through the federal court system, sometimes quickly, sometimes painfully, slowly. Anybody who thinks federal litigation operates at YouTube speed has clearly never met a federal docket. But eventually, procedure catches up with everybody. And ECF 175, hang on. Represents the court's assessment of what has occurred. I'm not going to turn that into something more dramatic than it is. I'm going to let the court's own language carry the weight. And now I want to address something important. There is a temptation when you receive a favorable ruling to start celebrating the ultimate outcome. I'm not doing that. I still have responsibilities in this case. There are still procedures that have to occur. There may be objections. There may be additional rulings. The district judge ultimately determines what happens with the report and recommendation. So I'm not standing here predicting the future. I'm talking about what exists on the docket tonight and tonight. ECF 175 contains a recommendation of default or for default judgment. That development, number one. That wasn't the end of tonight's story. I read from ECF 176. While everybody could understandably focus on the words default judgment, I wanted you to look at the very next docket entry, and I read from it. And unlike ECF 175, ECF 176, the one I just read from, is where we need to pay very close attention to the difference between a recommendation and an order, because ECF 176 addressed something I have been pursuing for a very long time. Discovery. More specifically, limited third-party discovery concerning the defendant's identity. And if you follow the litigation or this litigation, you know why that matters. The identity issue. One of the continuing issues in this case has been to establish defendant's identity. And now that will come through if the ruling is, the district court adopts all of this through evidence obtainable through third parties. And earlier in this litigation, I attempted discovery. The court said, not yet. There were threshold issues that needed to be resolved first, I learned. And the court made clear that discovery could not proceed at that stage. I had to respect that, so I did. Later circumstances changed. The litigation progressed, and I returned to the court asking for permission to serve limited third-party subpoenas. That request was opposed. Arguments were made about why I should not be permitted to proceed. And then today, the court ruled. We read it. That is an order now. And this is where today's second announcement became important. The court has authorized me to pursue third-party discovery to determine, unmask the defendant's identity. That doesn't mean I already have the answer. It doesn't mean that I know what particular third party, what they will produce. And it certainly doesn't guarantee what that evidence will ultimately establish. I need to say that up front now. But what it does mean is that I now have authorization from the court to pursue that discovery within the scope permitted by the order, and that is a very different procedural posture from where this case once stood. There is now a discovery period. The court established that period, and the deadline is now November 13th. Put that date on the calendar. I'm putting it on my calendar because it's been given to me as an order, and it's a countdown for me, a deadline that I've been given within that to proceed on discovering the defendant's true identity. Not because I'm predicting that will happen by then. I'm not. But because that is the timetable the court has established for complete discovery or completion of that limited discovery. And that means something important. This case has moved from you may not conduct discovery to discovery is now proceeding under a court-established schedule. That's movement. That's procedure. And that's why ECF 176 deserves just as much attention tonight as ECF 175. So, I know the next question. Somebody is inevitably going to ask, Teddy, who are you subpoenaing? When are the subpoenas going out? What information are you requesting? What do you expect them to produce? And here's where I'm going to disappoint the internet. I'm not announcing my litigation strategy. There are things that are appropriate to discuss publicly, and I will. The court's order is public. The docket is public. The discovery deadline is public. Friday the 13th, November the 13th. What I intend to do within that process, that's different. I'm going to follow the order, God willing. I'm going to follow the federal rules. I'm going to pursue the discovery the court has authorized. And I'm going to allow that process to unfold where it belongs, in the litigation, not in a YouTube preview of coming attractions. You've seen ECF 175, 176. We'll conclude it tomorrow, or read further. There may be more things to talk about. ECF 175 tells us what the magistrate judge is recommending, and ECF 176 tells us what the court has authorized. It's 11:38. There's a bigger lesson in all of this, and it isn't really about me. It's about the litigation. I've said repeatedly on this channel that lawsuits aren't decided on YouTube. They're not decided by who has the loudest panel. They're not decided by who can produce the most dramatic live stream. They are not decided by community posts. And they're certainly not decided by threats about what somebody is going to do or what is going to happen. Litigation happens on the docket, one filing at a time, one response at a time, one deadline at a time, one ruling at a time. And sometimes you don't like the ruling. I expected that. Sometimes the court tells you no. I experienced that too. Sometimes you have to go back, correct something. I've learned something, and there's things that I need to do that are in these orders. That's part of being a pro se litigant without an attorney in this portion up to now. But when the court tells you no, you don't get to pretend it says yes. And when the court tells you yes, you don't get to pretend, or you don't need to pretend it said anything more than that either. You read the order, you understand it, and then you proceed accordingly. I think I've said enough about this part for tonight. And there's that deadline. Let me take a look at your comments, and between now and then, God willing, God give me strength. God take my hand and lead me to that door, open that door, because I've been standing at that door. Open that door and guide me through it when I cross over that threshold into discovery. That's it for tonight. Let me look at your comments, and we'll wrap it up here. Just give me a moment. I've looked at the mail, and I appreciate you in advance for being respectful. Thank you. Yes, let's leave it with, in Jesus' name, amen. And I'm not ashamed at all, because it's Him that holds the future. I don't know what tomorrow's going to bring. I'm here now. I need Him to protect me and be with me. Keep me humble. Keep me alert. Keep me well. Keep me respectful. Keep me grounded. Thank you, chat, for your support and being respectful. Let's see if there are any comments that we can just pop up real quick. There's some new folks in the chat. I noticed there was someone who, new member, member for 29 months. That would be Latoya Woods. For the members, I did have a members only live before this live, a couple of hours before this live. And yes, it is so order. So let's see. Oh, it's hard. It's hard not to say something right now. Who is this with the membership, I believe? Thank you, Vicky, 42 months, a member. There was, I appreciate your support in the Bear Cave, supporting the mob and Unwind with Teddy. Let's see, Just Being Nosy is a new member. Thank you for joining Unwind with Teddy, new member, Just Being Nosy. Okay. And here we go.
no fault. I done doubled up on the workload. I think I fell in love with the bankroll. Pray up, get money, then we lay low. Add it up, bankroll, euro, peso, add it up. I'm just doing me, everything is on me. Oh, you matter what? Add it up, bankroll, euro, peso, add it up. I'm just doing me, everything is on me. Oh, you matter what? Add it up. Told her if it's all me, everything is on me. Gon' back it up. Matter what? Told you I'ma do me, why you hating on me? It's not adding up. Add it up. Told her if it's all me, everything is on me. Gon' back it up. Matter what? Told you I'ma do me, why you hating on me? It's not adding up.
Congratulations, newest member. Welcome to Unwind with Teddy and the Grizzlies. All right, let's see who else. Let me just make sure I uncovered all mics. Just being nosy. Okay. Driving home, baby Juju. Please be careful out there. And let's go down. Wow, 40 months. Happy anniversary. Ivy Jacinta. Mimi Twin, good evening. Thank you also for the jewels and the coins and the hearts and the gems and all of that. Thank you. Survivor One Official. Hello, chat. Congratulations on positive news. I appreciate you putting it like that. Positive news. That's what it was. I'll listen carefully. And Sharice Thomas. Love 777. Most people are in the bushes. Hey, Fiva, thank you so much. Regular supporter here and the Grizzly. Buzzball, good evening. Welcome back. Melissa 37 says hello to Teddy, Vicky, and Juju. Keep doing your thing. Got to stay focused. Also want to note that people forget how every judge district, etc., is different. You know what you're doing. Well, everyone is different. Every judge is different. Every case is different. Ange, good evening and welcome back. Replaying from the beginning, so you're behind. All right. Yeah, you get to learn a little bit more about what my case is about. And diabolical. Wow. Oh, wow. You're doing great. Hey. And says, wow, 12 minutes in, behind, and I'm in awe. I had no idea. Allegedly, she did all of this to Teddy. I will just say that, for those of you who have been following my case, no, but then there are so many like you tonight, Ange, learning for the first time what's in my case. And it's, I cringe at the thought that the mischaracterization of my efforts and my intelligence and what I put forward in this case and what I've gone through has been reduced to words like stupidity and old lady. And there's been a lot of comments by a lot of people, but I just want to remain focused, thoughtful. Facts are facts, so things are going to come out. I don't know what's going to come out, but, yeah. But there are a lot of naysayers and door knockers. Okay, I'll stop it there. and people who said, go and lose your case. That was cringeworthy. Um, I concur. YouTube has got to do something about people like her. Stubborn. 2026 is the year of reckoning. With God's help, justice must be served. It's one day at a time. We don't know. We don't know what we don't know. I think people understand I'm very conservative. So I'm going to still lean conservative on what's yet to come. I do think there's going to be some surprises. I don't know what that's going to happen. The golden coin. Yes, gold coins, 10 jewels. Thank you so much, baby Juju. Cherise. And the court talked about the gold or coins. Yeah, fishing out of a mouth. Yeah. Learn every day. Fair use commentary. Yeah. Thank you. You're doing amazing. Follow Unwind with Teddy. Say that, Judge. Yep. Teddy, we're with you, the Lord. Thank you. Perfunctory. Yes, words that I haven't heard in a long time. Like, oh, let me look that one up again. Reckless. D for disobedient. I'm tickled that the court sees all the patterns. Analyze that mess. Judge said they were stubborn several times. That's not my words. Disobedient. Bad thing. Or did citations. I want to be careful what I say because I know this all can end up in the objection that we both have 14 days. And you can best believe the expectation will be that there will be objections. Absolutely, in this case. Absolutely. They in this case, oh yeah. Oh yeah. They showed up day one. Oh yeah. If an objection doesn't come in, that will be a surprise. I'll just put it like that. So can't predict, but my expectation is that's what it is, and I'm just being transparent. I don't underestimate anything. Nothing. Nope. Don't know. I do know somebody said there were layers put into place and that they would have to be peeled back. Juju, those that endure to the end, thank you for enduring through it all. We still got a long ways to go. Teddy, you have been so patient and graciously waited for this time to move forward. Just don't know. Thank you. Lucky's commentary. Checking in. Tigerlicious. Hello, hello, hello. What is this? Check the community wall for updates. Yes. And changes to my schedule. And as a reminder, there will be more discretion moving forward. And some of this will no doubt be on members only for that reason. I had to wait for it. Yeah. And timing. Yes, timing. God's continued blessings. I just need him to I need him to be my eyes and my ears and my guide. I really do. There's things that I don't know. Wayne Normanesque. Hello. Wayne, thank you for still being here, hanging out with Unwind with Teddy. Welcome to the Bear Cave. Juju, even then, it would probably be limited to people closest to her. Either way, let's hope justice is served. We won't know until we know, will we? All comments and opinions. Lucky commentary says, I am not disappointed. That's right. Teddy, please keep the strategy under wraps. Yes, absolutely. Praise the Lord. God is with you in Jesus' name. And he is not slow in keeping his promises. No, not at all. He knows my heart. I don't even know my heart like he knows my heart. You got to know when to hold them and know when to fold them. And y'all hold them very well. Good night. Good night. Good night. Good night. Good night. Cans of tomato sauce. More sleepless nights. Oh, this is August. There's going to be a lot going on. 25 years of practice. What does that mean? Says, I asked because a court cannot recommend a default judgment. The motion has to be filed against you. All right. If you need help, go to my page. Okay. I guess a break from school is needed. I'm an attorney. Okay. Norman. Is that the Esquire? Okay. Now I see that. ESQ. All right. That's it for Detroit for tonight. We just under 1 a.m. I appreciate all of you tonight. Thank you so very much. All right. Is there anything else? I said counselor. Tigerlicious. Yes. Yep. So how did you hear about this channel? Have you been following us for some time? Or did you just tonight? I've got to ask, since you gave some information, is this your first time at this channel? On this channel? Hearing about this case? And what brought you here? Thank you. We appreciate you. Good night. Good night. Good night. Great live, Teddy. All right. That's going to do it for me. Biggest bear hugs go to each and every one of the honey bears and grizzlies. It's already tomorrow, or it's already, Friday. Is it Friday? It is. All right. That's it. Please hit the like on your way out. Thanks for watching. Until next time, join me tomorrow. And when I come back, that's it. Thanks for watching. Good night.